So Nicole is an attorney, and she's the founder and executive director of Shattering, which is a national
National
nonprofit
nonprofit.
addressing systemic, economic, societal, and political barriers that impede equality for women and girls. So before this, she was a practicing attorney for 3 decades. She was a litigator and also did merger and acquisition tax attorney. I saw you have your LLM. This girl has all kinds of law stuff. So 3 years of law school is enough for me. She went on and did even more than that. So Nicole has directly and indirectly experienced discrimination and gender pay equity inequities in the workplace. And those experiences, coupled with the kind of devastating, the devastating impact of the pandemic, led her to leave her attorney career and start Shattering Glass. So she found out pretty quickly that the ERA is very important and it's a very critical step toward gender equality. So she does a big focus on that, which is why we're going to listen to her expertise tonight. She's been quoted in multiple newspapers, including USA Today, The Washington Post. She's appeared on many media panels and on-air pieces, and she was named by Woman E-News as one of the 21 leaders for the 21st century. And she lives in the DC area with her husband, a teenage son and daughter. So I will let Nicole say anything else she would like to say about herself, and we will get going.
Thank you, Julie. Pretty much covered it all. Thank you again for having me. It's great to be back. For those of you who weren't with us in December, I did a presentation on the Equal Rights Amendment and where it stands today and why we desperately, well, it's ratified and why we desperately need it published in the Constitution. One of the key reasons is that the lack of the Equal Rights Amendment in the Constitution opened the door for the Supreme Court to issue the Dobbs decision, which overturned Roe versus Wade. Had the Equal Rights Amendment been in the Constitution, the Supreme Court would have been constrained. And we're going to get into that more as we talk today. But we also saw in Dobbs that the overturning of Roe was just the beginning. It was the first step in a series of rollbacks of the rights of women and LGBTQ plus people. And that is unfolding more so with each and every day. In fact, since the last time we were here together, we now have the first attempt at rolling back in vitro fertilization. So that obviously is on the forefront of all of our minds. And also what's next? Justice Thomas in the Dobbs decision gave anti-equality, anti-choice, reproductive rights, anti-gender affirming care rights, people a roadmap on how to go after the next set of rights. And that's what we're seeing unfold on a daily basis. So we've had some bad news since the last time we met, being the IVF decision, as well as, this stuff occurs almost daily. Yesterday, the Florida 6-week abortion ban was permitted to take effect 30 days, well, 29 days now. And partners at the Transformation Project are reporting about an onslaught of proposed legislation throughout the country. It's like nearly impossible to keep up with all of the different ways that they are trying to attack the rights of women, girls, and LGBTQIA plus people. But we have good news. So for those of you who heard, we're here the last time, the ERA is ratified, the ERA is ready. All we need is President Biden to pick up the phone and put it in the Constitution. So you'll hear a little bit more about that, as well as on January 29th of this year, so since last December, we received a Pennsylvania Supreme Court decision that makes clear that our federal Equal Rights Amendment will in fact protect reproductive rights and help us stop the rollback of all of these rights that we're seeing occur on a daily basis. And we're going to talk a little bit more about that. I'm briefly going to go over a background of the Equal Rights Amendment and where it stands for those of you who weren't with us the last time. But I'm going to keep that to a minimum. And at the end, I'm going to provide you a link to the other presentation as well as answer any questions you may have. But the Equal Rights Amendment states equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. 24 words, and they're highly controversial. It was introduced over 100 years ago, and it was overwhelmingly passed by Congress in 1972. 30 states quickly ratified the ERA within the first year, Hawaii doing it within a half an hour of it actually passing through Congress. And in order to have a constitutional amendment, you need 2/3 of each chamber of Congress to pass it, and 3/4 of the states then need to ratify. So for this purpose, we needed 38 states to ratify. So 30 states quickly did it within the first year, but then guess what happened? Roe versus Wade was decided. And as soon as there was a right to an abortion, the anti-equality folks went on a mission and stopped further ratifications. It completely slowed down the process. And by the end of 1979, only 35 states had ratified. So in the next 6 years, they only got 35, excuse me, they only got 5 more states. And why are we talking about 1979? You've probably heard that the proposing clause to the Equal Rights Amendment contained a 7-year time limit. It specifically said that the Equal Rights Amendment shall take effect when ratified by 3/4 of the states within 7 years. But that portion never went to the states for ratification, and hundreds of constitutional scholars have stated that because of that, there is no time limit on the Equal Rights Amendment. For purposes of this discussion, I'm not going to get into the details on that, but suffice it to say, we're dealing with a political question now. We're not dealing with a legal question. So after 1979, for a while, people had just assumed that that time limit was in effect. But then after, in 1992, the 27th Amendment related to congressional pay raises was passed and was fully ratified after nearly 203 years. At that point in time, people began to think about getting the last 3 ratifications that were needed for the Equal Rights Amendment. And in 2011, Supreme Court Justice Anthony Scalia said, there's nothing in the Constitution that prohibits discrimination. There's also nothing that requires it, but there's certainly nothing that prohibits it. Well, that got people thinking that we needed some equality in our Constitution. So in 2017 and 2018, Nevada and Illinois became the 36th and 37th states to ratify the Equal Rights Amendment. And the United States Archivist, who is an executive branch employee, accepted those ratifications and certified them, despite the time limit. When it became apparent in 2019 that Virginia was going to become the final state needed to push the ERA over the finish line and become the 28th Amendment, the states of Alabama, Louisiana, and South Dakota sued the government to prohibit the archivist from publishing the Equal Rights Amendment as the 28th Amendment. A few weeks later, the Trump administration, and the president has no role in the constitutional amendment process, interfered and issued a memorandum stating that the ERA was dead, had to start over, archivists couldn't publish the ERA. What that did is it shifted the burden of proof to the proponents of equality. And we've since had 5 lawsuits, one filed by the last 3 states to ratify, and one filed by two women's rights organizations, Equal Means Equal, and another women's rights organization. And then there have recently been 3 lawsuits filed by the Elizabeth Cady Stanton Trust trying to establish the validity of the ERA. Well, we're going to be unable to do that until the ERA is published. And the last Elizabeth Cady Stanton decision in Rhode Island made clear that publication has to come before enforcement. So why do we need the Equal Rights Amendment? And this is probably the most significant point, is that many people don't realize that when the 14th Amendment was enacted, women were not included as part of the class of people who received equal protection under the 14th Amendment. It wasn't until 1971 that that was done via court decision. But when they did it, they still didn't give women the full rights as men. So whenever you have a constitutional challenge, there are different tests the court uses to view them, dependent upon what the challenge is. So with sex-based discrimination claims, which applied when women were first given equal protection, they didn't receive the same rights as race, national origin, and religion did under the Equal Protection Clause. That special standard of review is called strict scrutiny. And what it does is it says the government has to have a really good reason, and it has to be so tight that it doesn't impact other rights for the law that's being challenged or the action that's being challenged. That level would apply to sex-based discrimination if the Equal Rights Amendment was in the Constitution. And with the Equal Rights Amendment in the Constitution, we would have a 73% chance of winning a sex-based discrimination claim. Before Dobbs, this lower standard that we had, intermediate scrutiny or heightened scrutiny is another name they call it, we only had a 47% chance of winning. And that's all we've ever had. We've only had this lesser standard. But what Dobbs did, it was a real game changer. It has effectively put into place the lowest standard of review possible, and it's called the rational basis standard of review. And with that, it's almost like the government can come up with any reason. It's a 20% chance of winning. This is what we're up against right now. We've historically had the 47% chance. We want the 73% chance, like we should have, like all other forms of discrimination get. Or are we going to get stuck with this Dobbs standard that's really going to leave women, girls, and LGBTQIA plus people without recourse? Unfortunately, there's currently a case queued up for the Supreme Court that addresses the Tennessee and Kentucky gender affirming care bans. And those bans, the case that is before the Supreme Court, the lower court ruled that sex-based discrimination gets that lowest 20% standard of review. So this is part of the urgency of getting the Equal Rights Amendment into the Constitution as soon as possible. And that's what Dobbs was about. It was always about more than just abortion. It was about keeping women, girls, and LGBTQIA plus people as second-class citizens. As a result of Dobbs and all this parade of horribles that we've seen, more people have started talking about the Equal Rights Amendment. And there's currently a joint resolution in Congress that calls for the United States Archivist to publish the Equal Rights Amendment as the 28th Amendment. Now, the archivist isn't going to do that unless President Biden picks up the phone, because the archivist has already been prohibited from doing that by the Trump administration. So we need the president to pick up the phone, call the archivist, and tell her now to put the Equal Rights Amendment in the Constitution as the 28th Amendment. And for those of you who don't know, the archivist is a librarian. The archivist doesn't have a law degree. This is a statutory duty to perform a ministerial act. It's like collecting signatures, counting them, and hitting print on the new Constitution. And the calls for publication keep getting louder and louder with each set of rights that gets stripped away. Particularly so after the IVF decision in Alabama. For those of you who aren't familiar, in February, the Alabama Supreme Court ruled that an embryo is a child for purposes of their wrongful death statute. And that effectively brought IVF care in that state to a halt. Now, because of the huge public outcry, they have since backed off on pushing for restrictions on IVF care, but that's only temporary. One of the public outcries was over the hypocrisy of the IVF decision. How can these people who are so pro-life deny families who so desperately want to have a baby the opportunity to do so? It would appear to be hypocritical. However, the purpose of the IVF rules, the IVF restrictions, and the abortion restrictions, and the contraception, potential future contraception restrictions are to keep women as second-class citizens. As a result of these restrictions, women will end up getting pregnant earlier. Currently, IVF has grown yearly as women wait longer to get pregnant, waiting into their mid-30s. And they turn to IVF with help to start a family or to grow their family. Those women who want children and want to have, for whatever reason, wait. But oftentimes it's to pursue a career, which we know may take women longer to establish themselves than men as a result of other forms of discrimination. Some women, if you take away IVF, and you have women getting pregnant sooner, and they may not be able to pursue the careers they want, like a doctor who's in residency until they're in their mid-30s. It would be difficult to have a young child at those times. So it's about more than just fetal personhood. Fetal personhood has been used for a while by the anti-choice, pro-life crowd. And I say that reluctantly because they're not pro-life. So then the question becomes, what can we do? State equal rights amendments, I'm not entirely sure how to get back to the last slide, but state equal rights amendments, as we discussed the last time, have been used to defeat abortion restrictions, which would also be used to protect IVF, protect contraception, because they would constitute forms of sex-based discrimination. Historically, the state of Connecticut and the state of New Mexico both relied on their equal rights amendments to defeat abortion restrictions, and those related to the state use of state Medicaid funds for abortion services. And in each of those cases, the court applied that high level of strict scrutiny, that 73% standard. The Dobbs decision triggered abortion bans across by Dobbs remains not in effect. So it still hasn't taken effect as a result of the Utah Equal Rights Amendment. And just last week, I think I saw some people here from Nevada. Nevada recently enacted an Equal Rights Amendment. I think it was 2 weeks ago now. The Nevada Equal Rights Amendment was used to defeat abortion restrictions. the challenge to the use of state Medicaid funds for abortion services. So we're seeing this use, but the most important decision of all was issued in Pennsylvania, and it was long awaited. It was issued in Pennsylvania on January 29th of this year. And why was it long awaited? Because the Pennsylvania Equal Rights Amendment is nearly identical to the federal Equal Rights Amendment. It's affirming what we've been saying all along, that we need the federal Equal Rights Amendment to defeat these abortion restrictions. As a result of this case, well, actually, let me step back for a second. In that case, the court specifically ruled that abortion restrictions constitute sex-based discrimination and are presumed invalid under the state Equal Rights Amendment. And the state can only rebut that presumption with strict scrutiny, and specifically said it's the government's burden to rebut the presumption with evidence of a compelling state interest in creating the classification, and that no less intrusive methods are available to support the express policy. The judicial inquiry will be searching, and no deference will be given to legislative policy reasons for creating sex-based classifications. Given these parameters, we acknowledge that few, if any, sex-based conferrals of benefits or burdens will be sustainable. What does that mean? That with the Equal Rights Amendment, it will be virtually unlikely for them to restrict reproductive rights. Now, this is particularly important for the people who are in states without equal rights amendments, like Ohio, like North Carolina, where I am. It's without the Equal Rights Amendment, we cannot restore Roe after the Dobbs decision. Congress only has the authority to act pursuant to enumerated powers in the Constitution. And when the Supreme Court stated there's no constitutional right to an abortion in the Dobbs decision, they had to find another way to be able to, I think we've heard, codify Roe or restore Roe. Unfortunately, there might be a chance of making a Commerce Clause argument, but this court has already said it will reject it. So even if we elect everybody needed to pass the Women's Health Protection Act, the Supreme Court's going to turn around and reject it unless the Equal Rights Amendment is in the Constitution. The Equal Rights Amendment, one of the provisions of it, other than those 24 words, says Congress is authorized to enact legislation to carry out the purposes of the Equal Rights Amendment. Well, that would be the Women's Health Protection Act. So the Equal Rights Amendment is step one before you can ever go to restoring Roe or codifying Roe. This Pennsylvania decision has had wonderful reactions from proponents of equality, proponents of reproductive rights. But on the flip side, well, let me say, it's made the calls for publication of the Equal Rights Amendment even stronger and more frequent. 2 weeks ago, the United States Congressional Democratic Women's Caucus, there's like 95 of the women, 94 or 95 women, congresswomen, put in their agenda to President Biden that he direct the archivist to publish the Equal Rights Amendment. We also are seeing numerous senators and representatives joining the joint resolutions urging the archivist to publish the Equal Rights Amendment, saying the ERI is ratified, the archivist needs to publish, that were introduced by Representative Cori Bush in the House and Senator Kirsten Gillibrand in the Senate. So though support for those resolutions are growing. Not to mention, you hear additional people like everyday people saying it, as well as medical professionals and associations, are now growing in numbers supporting the Equal Rights Amendment. In December, we did a letter to President Biden urging him to publish, and we had medical associations on that. And I'll provide you a link with that in the list of additional materials at the end. But most interesting of all is that the reaction to the Pennsylvania Allegheny decision from the Heritage Foundation and the Right to Life Committee. And they are concerned that this Equal Rights Amendment is going to get in the Constitution. Because if they do that, they're not going to be able to continue to restrict reproductive rights. Keep in mind that when President Trump blocked the Equal Rights Amendment in 2020, he already had a conservative majority on the court. He didn't need to block the Equal Rights Amendment. Unless, of course, it would have stopped the court from overturning Dobbs, and that was my overturning Roe, and that was my point to begin with. Had Dobbs been in the had the Equal Rights Amendment been in the Constitution, published when it was ratified on January 6th of 2020, on January 27th of 2020, Dobbs never would have happened. So the Heritage Foundation and the National Right to Life Committee, they're pulling out all the stops right now to try and, minimize the significance of the Equal Rights Amendment. And they've got a lot of money. They buy a lot of media. They issue a ton of propaganda, and they've upped their game. But we know what their concern is. Their concern is an anti-woman, anti-LGBTQ agenda. They made that clear at the hearing the Senate Judiciary Committee held on January 28th of 2023, when their concern was abortion on demand until 40 weeks, or, we're going to have, men in prisons or shared bathrooms, and all the fear mongering that occurred back in the 1970s. That just goes to show you how powerful this Pennsylvania decision was, that these people came out of the woodwork and they're going hard against the ERA. So I alluded to 5 cases before in terms of what would happen if the ERA is not published. The ERA is going to remain in a drawer in legal limbo. And as I said, we can't restore Roe or prevent further rollbacks of contraception, gender affirming care. We've seen laws that actually attack the existence of LGBTQIA plus people. These things are not going to stop. It is related to book bans. It is related to the Christian nationalist agenda. And we're also running the risk that we all lose equal protection because of the Scrimeti case that I referred to earlier. It's awaiting SCOTUS review, and we're going to run the risk that if the Equal Rights Amendment is not published in the Constitution, the same way it wasn't for Dobbs, that this Supreme Court will be free to apply that 20% you don't have a chance in hell of winning standard to sex-based discrimination claims. Julie, do you have any questions?
Somebody asked if the 7 years was disinformation that was done by the GOP.
It is not disinformation. It does contain in the preamble a statement that when ratified by the states in 7 years, and a preamble is like a proposing clause, it says we're going to talk about this and here's what we're going to talk about. And then they actually list the law. It's not in the law. Is it disinformation? All of the information that stems from the 7-year discussion is. So when there was a hearing on the Equal Rights Amendment, there's a resolution, not the 2 I was referring to, the joint resolution I was referring to. There's another set that is designed to send a message to the courts saying that Congress doesn't think this is an issue. They held a hearing on it, the one I referred to, and Following that, there were 50 articles saying that the deadline applies. It's a time limit and a proposing clause. It's like not a, so yes, there's a component of it that is misinformation. Will there be challenges? 100%. This Heritage Foundation, this National Right to Life Committee, they're not going away. They've been playing the long game for 50 years. I mean, they're going to go down fighting. But they needed the Equal Rights Amendment out of the way to even get this far. Sure, he packed the court, but he still needed to get the Equal Rights Amendment out of the way, and he did. So we need the president to put it in. So once it's in there, let the challenges ensue.
So then that same person asked, is it true that no state can rescind its ratification? That the ratification would have to be repealed by a new amendment like prohibition?
Okay, so there were rescissions related to the 14th Amendment and the 19th Amendment, and they were not respected. So we would be kind of on shaky ground if all of a sudden we started saying, oh, well, we're going to take rescissions. Well, is the 14th Amendment not in effect anymore? What was it not validly ratified? Has a court ruled no rescissions? Yes, rescissions? No, we haven't had a case that has addressed the validity of the Equal Rights Amendment. We can't get there. We can't get over the procedural hurdles, those 5 cases I talked about. But we have precedent where attempted rescissions have been ignored. And in fact, the joint resolutions of Senator Gillibrand and Representative Bush also reflect that rescissions were ignored in those 2 instances with those 14th and 19th.
So somebody said women are not mentioned in the Constitution except for the right to vote. Is that correct?
That is correct.
Okay, so does that actually mean that we don't own our reproductive organs and we need the ERA to have bodily autonomy?
Yes. Because right now you're dependent upon, there's nothing in the Constitution. You're dependent upon the Dobbs decision, which says there's no federal constitutional right to an abortion, bodily autonomy. We need the Equal Rights Amendment physically in the Constitution, like a valid part of the Constitution to establish that.
So can the archivist lobby the president to let her publish it?
Well, sure, in theory, but she's not going to lobby the president, because this may come as a surprise to folks, given that the Biden administration ran on an agenda for women. And the Biden agenda for women said, you know, he's going to make sure the ERA got taken care of. When the Trump administration blocked the Equal Rights Amendment from being published, those 3 states, Alabama, Louisiana, South Dakota, they withdrew their lawsuit. And then 2 lawsuits were filed, one by Equal Means Equal in another organization, and one by Virginia, Illinois, and Nevada, the last 3 states. The Trump administration fought both of those hard, saying the ERA is dead. Well, when the Biden administration came in on January 21st of 2021, everybody assumed he was going to publish the Equal Rights Amendment on day 1. Not only did he not publish the Equal Rights Amendment, and me and colleagues on the National ERA Publication Task Force were in contact with the White House counsel, we couldn't get an answer on why it wasn't happening. And then on March 5th of 2023, the Biden administration submitted, it was 2022, the Biden administration submitted a brief identical to the Trump administration fighting against the Equal Rights Amendment, and 20 blue states and 100 women's rights organizations in both cases. So the archivist isn't going to lobby the president, considering the president continued the Trump administration's policy.
Why did he do that?
That's the $1 million question. But I mean, I don't know, if you think about what happened yesterday in Florida, one of the first things out of the mouth of the Biden campaign was, time and time again, we've proven that when reproductive rights are on the ballot, we're going to leverage that for people to vote blue up and down the ballot. So is it for voting rights? Is it abortion rights? I can't tell you. The Biden administration wouldn't tell us. The Biden administration wouldn't tell the governors. We were working with the governors. The Biden administration's been really mum. That letter we wrote to 80 from 84 at the time organizations, and that's a diverse group. You've got democracy organizations, you've got medical associations, you've got LGBTQ plus organizations, you've got reproductive rights organizations, you have your typical racial and gender justice organizations you would expect there. You have political parties urging them. The North Carolina Democratic Party has urged the Biden administration to publish. Democrats abroad has urged Biden to publish. Nobody's getting an answer. And the thing is, it would be a win, right? That somebody's fighting for us. And as long as one of us is oppressed or one of us is unequal, it's meaningless.
Mhm.
We need to establish equality for everybody.
So I think you talked about this a little bit, but what can an individual do? I've seen in the chat someone has some place that you can text, and there have been some links
Yes.
dropped. So what is
So,
it? What's the thing that you want folks to do tonight?
okay, so I must have skipped that slide, but I am going to put in the chat a list of additional information, some of the things we've discussed, links to the letter, whatever that they can sign on to, and it specifically says the different kinds of things they could do. They most certainly, we have on our website, we have sample letters and links to send to the president, the vice president. You can text them. Both of them are accepting texts. The biggest thing is to spread this message. That is the thing we're running up against. We're running up against like a media blackout. We're running up against, I mean, you're listening to this presentation, right? It's like, part of us is like, why hasn't this happened? Could this possibly be true? And it took a lot to overcome that. And we need to spread the word. So here are the things. I'm going to drop this in the chat with the extra things we could do. And it includes spreading the word, taking action, visiting our taking action page, signing on to the letter. On the taking action page, you will see in specific instructions on what you can do and how to get it to the president and the vice president. And the keys to the vice president as well. One thing to think about is that when they were both presidential candidates, President Biden and Vice President Harris on the debate stage, Vice President Harris went at him hard. We have the video of it. And she's like, she had him on his heels in terms of, I've always supported the Equal Rights Amendment. And here we are today. Do I think the vice president would do it? It was a priority to hers in her first 100 days. She's just not calling the shots right now. But I don't know what his story is. Here is the link to additional things you can do and additional resources. It also includes my email and phone number. I'll answer anybody's questions about any of this stuff anytime. You can also follow us on social media and just share the stuff. Send the link. This includes the link to the first presentation we did that was broader, because Equal Rights Amendment isn't just about abortion and reproductive rights. It's about equal pay. It's about protection from domestic violence. It's about keeping guns out of the hands of domestic abusers, like the Rahimi decision. They're coming after no-fault divorces. So there's the link to that presentation. This presentation will be available, and I will always make myself available to anybody who wants to discuss these issues.
So if somebody asked if we lobbied the vice president, should could she be the one to maybe turn the tide? Meaning
No.
that she could get, maybe get Biden to, tell the archivist to do what they're supposed to do.
No, it's got to come from the president. I mean, for all we know, I think the vice president, I mean, if somebody can get to the vice president, that would be great. But she's pretty insulated with the Biden team, and she's not calling these shots. Do I think that, I mean, Vice President Harris was on the Constitution Committee of the Senate Judiciary Committee when Trump blocked this. She knows what's going on. It's got to, somehow we have to move President Biden. And I don't know where the advice is coming from, but it's just not solid. Yes, I'd be happy to speak to a local chapter of Red, Wine, and Blue. Absolutely. And Maryland has a strong ERA group as well too. Yes, I would be happy to speak. And my contact information is on that blog I posted, and I'll just stick it here too.
And Nicole can send me all the resources and her contact information, and I'll send an email probably tomorrow morning with all of that to anybody who attended tonight.
Thank you.
And that was the majority of the questions that we had, because most of them are, how do we push the president to do this? So, that's been really some variation of, I've got like 5 questions here, and that's some variation of, how do we get him to do this? Why isn't he making the call? Is it because he needs to win those states in November? Are they derelict in their duties? So those are the questions that, kind of all wrap right around one another.
Right.
This is, to me, this is very, this is just absolutely terrible and awful, because, the Constitution started out saying that people who look like me were only 3/5 human. So
Right.
if I'm a woman, then what am I now?
Yeah. No. Right. You can vote.
This
You
is
can vote.
absolutely frightening.
It is very frightening, Julie. It is very frightening.
Hey,
And
Nicole.
as we know from the way the discrimination works, it's intersectional. And the more the biases, the greater the discrimination, the greater impacts on the individual. So, yes, it's very frightening.
Nicole, I'm curious. So why was the court decision made that discrimination or challenges to equality for women were only like the mid-level scrutiny and not the same strict scrutiny that you get with like race cases? What was the decision in that case that made that intermediate scrutiny level? I'm just curious.
Okay, so the case I believe was Craig v. Warren. And what happened in that, there was this big concern that there were going to be times when you wanted to do something different for women. Like you didn't want them to go in the draft. So you wanted to have, the state needed to have a little wiggle room. Now, none of these rights are absolute, right? It's not a per se guarantee that if the Equal Rights Amendment is in there, you can then have, a live birth like abortion at 40 weeks, like they're saying. Of course not. That would be a compelling government interest that's narrowly tailored, and no right is absolute. But in the Craig v. Warren thinking, it was these instances again, Julie, with the men in the bathrooms or in the women's spaces and being at risk. It's the same fear mongering right back then that gave us this lower standard. And Julie, I've said this to you in the past. I never fully understood how bad it was. And I was the lawyer who took a year's worth of con law like you. It's like it was only when I was focused on it full time that I realized the difference.
100%. Like, what did I miss in law school that I didn't know that? You know what I
They
mean? Like,
probably didn't teach us. They didn't want us to know. There were too many of us showing up. At that point, we're probably getting close to 50%. They didn't want us to know.
Someone said women served in the armed services during war and died, but didn't get the same GI benefits. Is that still true today?
I do not know that. But I mean, I can tell you that there's a gender pay gap at the White House. Like there's inequality everywhere.
Even after the Lilly Ledbetter, there's a gender gap at the White House.
Yeah, the gender pay gap at the White House, Julie, is now greater than what it is as a national average. So this year it's 84 cents. I can't remember if the White House is 80 or 81
That's
cents.
disgusting considering they have a lot of women of color
Right,
in those positions. That's really gross.
right.
Huh.
Someone dropped a link to the 19th article about it, so that was interesting to read as well.
So Cynthia asked a question about what parts of the ERA talk about LGBTQIA plus rights. It is the combination of the Bostock decision that said discrimination based on those rights is sex-based discrimination. The Bostock decision was done in the context of employment, but it's had a more widespread read since then that it should go beyond employment. So it's a combination of the Bostock decision and the Equal Rights Amendment. So Bostock gets you sex-based discrimination for LGBTQIA plus restrictions, and then the Equal Rights Amendment would apply to the sex-based discrimination. So it's two-part. The same way that sex-based discrimination doesn't say women. It applies to both men and women. It makes sure everybody's treated the same regardless of sex.
This was a lot of technical info and court cases and standards of scrutiny. So I think I applaud everybody for hanging on and listening. I think it was so informative, and I know we've all learned things that we never learned. So thank you, Nicole, for your time, and Julie for wrangling all the questions. And we will.
Thank you. And thank
Yeah, I'll
you
let
for
you
having me,
say
and
what you
all
want to
these
say.
wonderful people for being interested and willing to take action. Just spread the message far and wide, and email and text the president. So grateful for all of you. We just need a lot of people, because at the end of the day, I think we just need to get them over the hump.